Thank you all for coming this morning. We're eager to dive right into our topic because it's a topic that is of great consequence for the future of the country and indeed the world in which we live. Thank you for joining Hillsdale College this morning for our first Principles on First Fridays lecture series. My name is David Bobb. I direct the Alan P. Kirby Jr. Center for Constitutional Studies and Citizenship. This is a program of Hillsdale College that is based in Washington, D.C. We're dedicated to the same thing that Hillsdale College has been dedicated to since its founding in 1844, and that's the education of particularly young people, undergraduates, but also anyone who's interested and willing to think hard about things like the history, the political thought, the foundations of this country. You can find out more about the Kirby Center and our mission online. We have a number of programs, and we'll be launching a number of lecture series in addition to this one in the coming months. You can find that information at the Kirby Center, KIRBY Center.org. This morning's Washington Post has the headline, Obama Aides Near Reversal on 9/11 Trial. Now, as our speaker this morning, Andrew McCarthy, will tell us sometimes you have to be wary even of the Washington Post headlines. We're really thrilled that Andy can join us this morning. He has a tremendous record. I'm sure that many of you have read him. He's already posted this morning, and he's already done a studio appearance at Fox News. He's been just a real leader in educating Americans about the topic that we're looking at this morning. That topic is America's war on terror, or is it? And joining me this morning to introduce our speaker is Hillsdale College student Jason Statler. Jason is part of the Washington Hillsdale Internship Program, WHIP for short. WHIP has been around for about 35 years and has sent hundreds of Hillsdale College students over those years to Washington, D.C., where they serve full-time internships, take a couple of classes, and engage in a series of co-curricular activities like going to Gettysburg and all the many wonderful sites and things to explore in Washington, D.C. Jason is gaining experience in his full-time internship at the American Trucking Association. He's a political science major, a junior, and will now introduce our speaker. Jason.
Good morning. Andrew C. McCarthy is a senior fellow at the National Review Institute, a contributing editor at National Review, and co-chairman of the Center for Law and Counterterrorism, a joint project of National Review Institute and the Foundation for Defense of Democracies. He is the author of the New York Times bestseller, Willful Blindness, a memoir of the jihad. His next book, The Grand Jihad, How Islam and the Left Sabotage America, will be published by Encounter this year. For 18 years, Mr. McCarthy was an assistant United States attorney in the Southern District of New York. From 1993 through 1995, he was the lead prosecutor in the terrorism case against Sheikh Omar Abdel Rahman and 11 others in connection with the 1993 World Trade Center bombing and plot to bomb the New York City landmarks. He served the office in several executive staff positions, supervising the training of new prosecutors and preparation of briefs and arguments before the United States Court of Appeals. Following the 9/11 attacks, he supervised the Justice Department's command post near Ground Zero in New York City. In 2004, he served the Pentagon as Special Assistant to the Deputy of the Secretary of Defense. Mr. McCarthy has been an adjunct professor at both New York Law School and Fordham University's School of Law. He is the recipient of numerous awards, including the Justice Department's highest honors. In addition to being featured regularly in the National Review, his articles have appeared in the Wall Street Journal, the New York Times, Commentary, the Weekly Standard, the American Spectator, and many other publications. This morning, Mr. McCarthy will speak on the topic, America's War on Terror, or is it? Please join me in welcoming Andrew McCarthy.
Well, thank you so much. It's a great honor to be here this morning. David was good enough to mention all my great accomplishments of just this morning, Fox News and getting a post up on the corner. What he didn't tell you was this great leader of men made the wrong turn coming out of the hotel this morning and went about 3 blocks out of my way. So I've also had my run, as it turns out. You would think that being in a hotel only about 4 blocks away would not be a major catastrophe, but there you have it. I do want to talk a little bit later, maybe when we get to questions, maybe at some point, about the article in the Washington Post this morning, because I actually do think it's something of a head fake. But we can talk about that. What I want to first do, though, is address the topic I was asked to address, which is America's war on terror, or is it? I want to begin with a story from early in American history. You are hereby commanded to show cause. The general studied this document in his hands. It was a writ of habeas corpus issued by an American court. A federal judge was presuming, in the midst of war, to order the commander in a combat theater to report to the courthouse the following morning and explain himself. On what basis, the judge demanded to know, was the United States Army holding a prisoner of war? Habeas corpus, you shall have the body. It is known as the Great Writ, an 8th-century-old creature of the Magna Carta, of British common law, of Western Enlightenment tradition. It was first formally established in the colonies in the 1690s, about 85 years before the Declaration of Independence. When the Constitution was adopted in 1787, it became part of our fundamental law, enshrined in what's called the Suspension Clause, Article 1, Section 9 of the Constitution, which says, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it." The writ, in short, is our time-honored bulwark against tyranny. But tell that to Louis Luuyler, and while you're at it, tell that to the Honorable Dominic Augustin Hall, the United States District Judge in Louisiana. Louisiana had only been a state for about 3 years when, in early 1815, the commanding general in question, Andrew Jackson, authorized the arrest and detention of Louis Luuyler. The late, great Chief Justice William H. Rehnquist told the story in his gripping book about civil liberties in wartime, All the Laws But One. Old Hickory had just saved the Republic by defeating the British forces of General Sir Edward Parkenham in the decisive Battle of New Orleans. It doesn't do the victory justice to say that Jackson had won the War of 1812. The Treaty of Ghent, which formally concluded the war, had actually been signed by British and American foreign ministers over 2 weeks earlier, but news of the treaty did not reach the United States in time to forestall the battle. It became the one great American victory of the War of 1812. Just as Jackson hadn't known about the formal armistice, so too he did not know what the British would do with their defeated army. Would they regroup and attempt another assault? With the outcome and survival itself still in doubt, Jackson imposed martial law. He was determined to maintain it until he knew for sure that hostilities were over. This did not please Mr. Luuyler. He took to the newspapers to attack Jackson and Jackson's imposition of martial military law and order. Perceiving this as a very untimely incitement, Jackson had Luuyler arrested. Aroused supporters of Luuyler, the imprisoned man, appealed to Judge Hall. The jurist, like any jurist, had utterly no responsibility for the national security of the United States. The framers intended that national security decisions be made by elected officials accountable to the voters whose lives are at stake. The judge's only duty was to ensure that the litigants before him received due process. Because that duty is a limited one, Judge Hall, like all federal judges, was politically insulated in executing it. Yet the judge was of a mind that he, not the United States Army, personified the rule of law. Security or no security. General Jackson was of a different mind. Instead of responding to the writ as directed at 11 o'clock the next morning, Jackson had Justice Hall arrested. After a time, he had him escorted by troops several miles outside the city limits, where he was finally set free. I think it's fair to say that we've come a long way from Andrew Jackson to Barack Obama. And I think it's probably even fairer to say that we've come an even longer way from Louis Leweiler to Umar Farouk Abdul-Muttalib, the Christmas bomber. It's become fashionable in this era of hope and change to invoke the rule of law, that phrase in quotes, as if it meant the rule of lawyers, and in particular the rule of robed lawyers. That, however, has never been the term's meaning, nor could it be in any republic that hoped to stand the test of time. Yes, we are always beholden to the rule of law. In the United States, however, the rule of law is embodied by the Constitution. Embodied, not personified. The rule of law consists of the Constitution and the statutes, treaties, rules, and regulations adopted pursuant to it. The rule of law does not refer to the government officials who apply or purport to apply the Constitution, whether they are judges or officers of the political branches. These officials are our servants, the Constitution's servants. They are not our rulers. It has also been trendy in recent years, especially among our legal elites, to declaim in all due piety that the Constitution is not, quote, suspended in wartime. Suspended, by the way, is a clever choice of words. It's an attempt to trace the lineage of this absurd statement that the Constitution is not suspended in wartime to the great writ of habeas corpus and to the diction of our fundamental law of the Constitution. Of course, no one who believes that our nation has a natural right to defend itself believes the Constitution is ever suspended. The Constitution is not, however, nor has it ever been, the imposition of judicial rule. Indeed, the Constitution imposes strict limitations on the judicial power, just as it does on the powers of other government actors. It has never been the case that where judicial power ends, anarchy begins. General Andrew Jackson may have been wrong to lock up Louis Leweiler. In fact, a military court that was set up to try Leweiler actually ended up acquitting him of inciting mutiny and insurrection. Still, Jackson was not wrong in determining that it was his decision to make, not as a tyrant, but within the constraints of military protocols. We were not in peacetime, and in fact, the moment formal word of the Treaty of Ghent reached New Orleans, Jackson immediately reinstated civilian rule. But until that time, the civilian courts were not responsible for keeping order in New Orleans. They were, in that time of crisis, inadequate to that task, unless you think Justice Hall and his stack of writs were a match for His Majesty's armed forces, then thought to be the mightiest on earth. General Jackson was applying a principle stated with clarity almost a century later by Oliver Wendell Holmes, Jr., a legendary Supreme Court justice and progressive thinker, but also a decorated veteran of the Civil War. As Holmes put it, writing for a unanimous court, I believe in 1909, when it comes to a decision by the head of the state upon a matter involving its life, the ordinary rights of individuals must yield to what he deems the necessities of the moment. Public danger warrants the substitution of executive process for judicial process. When the life of the state is imperiled, the Constitution does not disappear, it adapts. In times of armed conflict, it imposes the laws and customs of war, which are every bit as much a part of the rule of law as judicial processes are in peacetime. On this point, it's worth pausing to remember why we have a Constitution. After independence, our new country had tried to survive and thrive under the Articles of Confederation and Perpetual Union. The experiment was a failure for many reasons, but paramount was its construct of national security by committee. That turned out to be very ineffective security indeed. It allowed England to ignore its treaty commitments, Spain to choke off the Mississippi River, and U.S. flagged ships to be besieged by the Barbary pirates, in America's first experience with Islamist terror. As you may know, that's how we got the U.S. Marines, from the halls of Montezuma to the shores of Tripoli. The Constitution remedied this potentially fatal weakness of the Articles of Confederation. It endowed all executive authority, including the powers of commander-in-chief, in a single government official, the President of the United States. Our fundamental law was conceived and adopted this way, with powers that could be awesome in confronting threats, precisely because the framers knew a basic point that seems lost on us today. The United States is not necessarily forever. The rights we cherish, the freedoms that define us as Americans, would be little more than parchment promises unless we could defend ourselves and defeat our enemies. Moreover, unlike today's left, the founders understood that we would always have enemies, real enemies, not, as Mark Stein memorably puts it, just friends whose grievances we haven't yet accommodated. We would not be able to define our enemies out of existence by not uttering their names. We would not be able to rationalize them out of existence by insisting that their hostility is somehow our fault, and therefore within our power to reverse, if only we would change ourselves. And we most certainly would not be able to indict them into submission in our civilian courts. We would have to defeat them, which meant we would have to be able to enforce the protocols necessary to wage war successfully. These protocols are the laws of war. They are older than the United States. They are common sense defense measures, requiring combatants to wear uniforms, to carry their weapons openly, to be part of a regular armed force, and most importantly, to refrain from intentionally targeting civilians. They also define wartime powers and privileges. Enemy combatants, for example, may be captured and detained until the conclusion of hostilities. Fighters who adhere to the laws of war are honorable combatants, privileged to use force, and entitled to various protections upon capture. By contrast, fighters who flout the laws of war, such as non-uniformed terrorists who target and savage civilians, are unlawful combatants. They are not privileged to use force, they are not entitled to the protections of honorable soldiers, and they may be prosecuted by military commission if they commit war crimes. This is every bit a legal system, but it is not a judicial system, and it is not intended to be. Throughout our history, at least until September 11, 2001, we seem to know that. Chief Justice Rehnquist's book was called All the Laws But One, as an homage to Abraham Lincoln. It has been widely noted by the left's legions since 9/11 that the Supreme Court ultimately rejected President Lincoln's suspension of habeas corpus to quell insurrections during the Civil War. Not as often mentioned is the fact that Congress actually endorsed Lincoln's action when it returned to session. Remember, those were the good old days when Congress wasn't in session all that often. Also overlooked is the fact that the legal question before the Supreme Court was a very close call. The suspension clause only says when habeas corpus may be suspended. It does not tell us who has the power to do the suspending. Chief Justice Roger Taney concluded, in a case called Ex parte Merriman, that because the framers located the suspension clause in Article 1, which defines the powers of Congress, rather than Article 2, which defines the powers of the President, it must have been understood by the framers to be a power of Congress, not a power of the President. That's a reasonable interpretation, but it's hardly indisputable. And there was something far more implausible in the case than President Lincoln's belief that he had the power to suspend the writ as long as the conditions that are laid out in the Constitution had been satisfied. It was Taney's claim, this is the thing I think was more implausible, Taney's claim that if the courts were open and functioning, even in wartime, federal judges, not the political branches responsible for prosecuting the war, would have the final word on what actions could be taken in the defense of the United States. That contention has no support in our founding law. It was a power grab, pure and simple, and a foolish and undemocratic one at that. Most missed, however, has been Lincoln's explanation for his action. At the time, the very survival of our Union hung in the balance, with Confederate sympathizers sabotaging railways and otherwise impeding Union forces from reaching the battlefield. It is for just these exigencies that we have a suspension clause. As President Lincoln eloquently reasoned in a message to a special session of Congress on July 4, 1861, if the writ of habeas corpus, fashioned with such extreme tenderness to the citizen's liberty, were as sacrosanct as Taney contended, it would allow all the laws but one to go unexecuted, and the government itself to go to pieces, lest that one be violated. It's a preposterous notion. What of the president's obligation to preserve, protect, and defend the Constitution? All of it, not just the writ of habeas corpus. What of the central purpose of government to provide for the common defense? What becomes of the rights we cherish if the structure so carefully crafted to defend them vanishes? These were the challenges with which Lincoln grappled, and they were challenges with which FDR grappled as well in the Second World War. In June 1942, the dark hours of World War II, when the outcome was anything but clear, 8 German saboteurs were captured after landing off the coasts of Long Island and Florida. They had been sent to the United States by the Fuhrer himself to commit acts of terrorism against civilian infrastructure that was critical to our war effort. The commander-in-chief decided to make an example of them. FDR wasn't interested in the fact that the federal courts were open and functioning, nor was he swayed by the fact that one of the saboteurs happened to be an American citizen. President Roosevelt directed that they be detained without civilian charge as enemy combatants, and further, that they be tried by military commission. Nor did FDR, unlike today, perceive the need to festoon the proceedings with the trappings of a martial setting. The commission took place not at a military base in but in an FBI conference room in what is now the Robert F. Kennedy Department of Justice building, just a few blocks away from where we're meeting this morning. The defense lawyers naturally cried foul. They filed a petition for a writ of habeas corpus in the Supreme Court, claiming that the military trial violated the Constitution, given that the courts were open and functioning in the United States. Upon hearing about the petition, FDR, the famed progressive president, summoned his Attorney General, Francis Biddle, the famed progressive civil libertarian. FDR told Biddle to communicate to Chief Justice Harlan Fiske Stone in no uncertain terms that he didn't care what the Supreme Court thought. The Constitution, not him, not the justices, the Constitution made him, not the justices, responsible for the national defense, the lives of the American people, and the successful prosecution of the war. FDR said he would not be releasing the prisoners, regardless of the court's disposition of the case. This proved to be something of a judicial king has no clothes moment, a moment of clarity such as we have not had, I would say, in the ensuing half-century plus. The brute fact is, courts have no power to enforce their edicts. The persuasive force that induces us to honor their rulings is the perceived legitimacy of those rulings. FDR was willing to bet, if it got down to brass tacks, that the American people would decide the commander-in-chief they had chosen, the president who would have to face them in the next election, was the government official they wanted running the war and protecting the country, not a tribunal of unelected lawyers whom they could not remove if they got vital security questions wrong. In the event, the Supreme Court was also willing to bet that Roosevelt was right. In the famous case of Ex parte Quirin in 1942, the justices somehow found it within themselves to uphold everything FDR wanted to do. And in another stark departure from today's ambivalence about war, the entire episode, from capture in June until the execution of most of the saboteurs in August, took about 7 weeks. What is the real difference between then and now? How do we go from Jackson and Lincoln and FDR to the Obama administration's stunning mishandling of the so-called Christmas bomber, Omar Farouk Abdul-Muttalib? Recall that the man who tried to detonate a chemical bomb on an airplane, an attack that would have killed 288 innocents aboard and an untold number of Americans on the ground, was a trained al-Qaeda operative. We are in a congressionally authorized state of war with that transnational jihadist terror network. Abdul Muttalib was a Nigerian national sent from Yemen to attack us. He had no claim on the protection of civilian due process and no claim on the protection of our Constitution. What's more, our intelligence community tells us that Yemen is currently one of the prime launch points of anti-American terrorism in the world. Abdul Muttalib had spent 4 months there. He knew the training camps, the trainers, the identities of other terrorists, evidently scores of them, who had been trained and are being trained to carry out just the same kinds of atrocities that he was trying to carry out. That is, his capture alive should have been one of the great intelligence coups of this war. Instead, he was questioned for a mere 50 minutes before being given Miranda warnings and the assistance of counsel. He naturally invoked his supposed right to remain silent, and was consigned to the civilian justice system. He was charged in an indictment that gave him plea bargaining leverage in any further negotiations over whether he would share with us what he knows about al-Qaeda operations. This was completely unnecessary. Abdul Muttalib could and should have been designated as an enemy combatant and interrogated without the interference of a lawyer or the complications of a criminal prosecution. Even if one believed, as the Obama administration says it believes, that it is important to our reputation in the world to endow him with all the rights of the Americans he was trying to slaughter, there was no legal requirement that that be done now. He could have been turned over to the civilian authorities 2 or 3 or more years from now, once his intelligence reservoir was fully tapped. We'd have lost nothing but the ability to introduce any confession that he made at trial. And any competent prosecutor will tell you that no confession is needed when a terrorist attempts to bomb a plane in front of about 300 witnesses. Where have we gone so wrong that we believe our security can be entrusted to judicial processes? To answer that question, we need to return to the era of FDR, and specifically to Robert Jackson. Jackson was a giant in the political and judicial realms. The Attorney General Roosevelt appointed to the Supreme Court, and he was later tasked by President Truman to prosecute the Nazis at Nuremberg. When he was a Supreme Court justice, writing for the court in a 1948 case called Chicago and Southern Airlines versus Waterman SS Corp., Jackson explained as follows. It's a little bit of a lengthy quote, but I think it's worth going through. The very nature of executive decisions as to foreign policy is political, not judicial. Such decisions are wholly confided by our Constitution to the political departments of the government, executive and legislative. They are delicate, complex, and involve large elements of prophecy. They are and should be undertaken only by those directly responsible to the people whose welfare they advance or imperil. They are decisions of a kind for which the judiciary has neither the aptitude, facilities, nor responsibility, and have long been held to belong to the domain of political power, not subject to judicial intrusion or inquiry. The Constitution of Robert Jackson, like the Constitution of Andrew Jackson, which is to say the Constitution of the Framers, is a constitution for a free, self-determining people. Such a people does not surrender control of the most fundamental questions made by any body politic, the decisions about national defense, to officials who, however well-meaning, are not politically accountable to the people whose lives are at stake. That surrender is not the rule of law. It is the acquiescence in judicial despotism. Unless we reclaim our democratic prerogative, namely, placing national security back in the control of elected officials who answer to the American people, we shall be neither safe nor free. Thank you very much. I'm happy to take questions.
Mr. McCarthy, as someone who tried terrorists in civilian courts, can you explain sort of the progression from your support for that to now the changes in law that led you to believe that it's no longer the way to go?
As far as my support for it is concerned, I'd like to hark everybody back to 1993 to try to clarify this a little bit. It's not like anyone back in 1993 sat around a table and said, war, crime, which is it that we're dealing with? We had no experience to speak of in the United States. I'm not saying there weren't episodes, but in terms of a systematic assault by international terrorists, particularly when they were attacking us in our own homeland, that was not something that the government was prepared to deal with. It was certainly not something that our law was planned to deal with. In fact, terrorism law had to be drastically overhauled in 1996 because the charges that we had to bring back in 1993 were so paltry. Let me give you one example. If you successfully committed a bombing in 1993 and people actually were harmed or killed, we had a bombing statute. We could prosecute you and you could go to jail for life. The federal death penalty was on the shelf until 1994, but you would at least get life in prison. But let's say you committed a conspiracy to bomb, which the government was either lucky enough or savvy enough to break up, which is what happened with the second part of our case. The first part was the World Trade Center bombing. The second plot was a plot against New York City landmarks, the Lincoln and Holland Tunnel, the FBI's Lower Manhattan headquarters, the UN. By the way, the next time that someone tells you that terrorists aren't really irrational, in 1993 they wanted to bomb the UN because, as we all know, it's a tool of American authority and power in war. But anyhow, to bring such a conspiracy where it was a plot to kill tens of thousands of people, but they didn't carry it out, we had no statute for that. So you had to bring it under the catch-all federal conspiracy statute, which had a penalty of 0 to 5 years. So we had very paltry charging apparatus back then. 1996, all that changes. We have all these terrorism conspiracy statutes and material support statutes. After 1996, you can have a robust argument about whether we ought to be treating this as a civilian matter or a military matter, but you could no longer complain if you were a prosecutor that you didn't have adequate tools to address the people who actually did get brought into civilian court. But to go back to 1993 for a second, the military can't operate inside the United States. It has bases inside the United States, but it can't do, enforcement operations because of what are called posse comitatus restrictions. As a result, back in those days, the only organizations domestically that trained for catastrophic events, not just terrorism events, but any catastrophe, whether it was insidious or accidental or what have you, the only organizations that trained for that would be the police, the fire departments, the first responders, etc. February 26, 1993, in the middle of the day, about 17 minutes after noon, the World Trade Center is bombed. And what ends up happening is what ends up happening whenever there's any catastrophe, and that's what happened in those days. People responded instantly without anybody really thinking about it. Nobody sat around a table and said, how should we deal with this? We didn't even know what we were dealing with. But suddenly you're in an investigation. And then within about a week, we had 4 or 5 people in custody. And when you have people in custody, one of the things that happened in the Abdul Muttalib case as well, when someone comes into federal custody and they're denied bail, the government is required to indict them within 10 business days. So in the blink of an eye, virtually, you have a case, and then you're getting ready for trial, and you're assembling documents, and you're trying. In our case, we had a twofold problem. First, we were dealing with a threat that we were utterly unprepared to deal with, and secondly, we found out right after the first bombing that they were plotting a second bombing. So we're trying to wrap our brains around what the threat is that we're up against. It's really pretty foreign to us. And at the same time trying to conduct another investigation to make sure an even worse attack than the Trade Center bombing doesn't happen. So I don't know that you could say that I sat down in 1993 and said, gee, this is a crime. There wasn't any decision to make. It just, it was rote activity. But I will say this, and I write about this in the book. I very much wanted to believe, and did believe, back in 1993, what the gospel according to the Justice Department and the rest of government was, which was that it was a matter of great importance to our reputation in the world that we bring our enemies into the majesty of our Bill of Rights, the majesty of our criminal justice system, vest them with all the rights that we would give American citizens, and show the world how we treated them versus how they treated us. I thought that would be a powerful symbol. I think the reason you believe something like that is because it sounds so admirable. But when the rubber meets the road, it's not true. It doesn't make any, it doesn't make any sense. Right now, for example, let me give you one example, and then I'll take another question. We're having this big argument about whether we should close Guantanamo Bay because supposedly Guantanamo Bay causes terrorism. It's a symbol of, I don't know what it's a symbol of. I think it's a symbol of George Bush, and they don't like George Bush. But the theory is that it causes terrorism because it shows that we don't apply our ordinary rule of law to Islamic terrorists, who, by the way, we're at war with, but that, by having this sort of off the criminal justice system place for incarcerating them, we're somehow disrespecting the Muslim world and not bringing them into the majesty of the Bill of Rights anymore. And what I always say when I hear that is it's a couple of things. First of all, it confuses a pretext with a cause. Terrorists will use anything as a pretext for why they commit terrorism. But terrorism isn't caused by Guantanamo Bay. What causes terrorism is Islamist ideology. And we can have a long conversation about that, but it's a 14th century old ideology. It is not a fringe ideology. It's much more mainstream than we would like to believe. But suffice it to say, for present purposes, that that's the cause. The pretext is Gitmo or Abu Ghraib or Israel or whatever they're using this week. They'll always come up with something like that. But the guy who I convicted, we actually convicted a number of people in that case, but the main defendant was the blind sheikh, who was a very powerful and legendary figure in jihadist circles, even by the time he got here. He actually is the one who issued the fatwa, the Islamic edict for the murder of President Anwar Sadat in the early 1980s. And bin Laden, by the way, credits him with having issued the fatwa that approved the 9/11 attacks, too. So, we're talking about a fairly heavy-duty guy. But anyhow, we brought him into our criminal justice system. We gave him, the nice civilian trial, and he's in a nice civilian jail. He's not at Guantanamo Bay. His followers, particularly the Islamic group, which is a terrorist organization in Egypt that he runs, have committed several atrocities, including a really horrid one in Luxor, Egypt, in the late 1990s, where some of the jihadists set upon a group of over 50 tourists and brutally murdered them with guns and knives and left pamphlets around, including pamphlets in some of the corpses, saying that they were demanding the freedom of the blind sheikh. Now, it didn't seem to impress them very much that we had him in this nice civilian jail after giving him the civilian trial. And the thing I think we need to remember about that is we're talking here, in terms of who we're impressing in the world, right? We're talking here about Sharia societies where they still enforce brutal hudud penalties, as they're called, stonings, all manner of stuff. I often think about, a couple of people coming home from the Friday stonings, in Saudi Arabia or Iran or some, and saying, what really offends me? Guantanamo Bay. They don't even let them see a lawyer for several months. How crazy is that we think that they're going to be impressed. There is rampant illiteracy in that part of the world. In many parts of it, they think that studying the Quran is the be-all and end-all of what education needs to be. I don't say that to be derogatory. I say it to make a simple point. The thought that they know the difference between whether somebody is in a civilian jail because he's been prosecuted on the basis of a judicial indictment where the government proved beyond a reasonable doubt all the elements of the offense, or that they're in Guantanamo Bay under the laws of war, which allow us to detain until the conclusion of hostilities. You got to be kidding me. I mean, they don't, there's not a chance that they would appreciate the difference. Hey, look, a lot of us don't appreciate the difference. So I don't know who we think we're impressing. Sir, I think they want you to have a microphone.
Ken Jones from CQ Press. Apart from the location, what are the practical differences between prosecuting KSM in a military tribunal as opposed to the civilian court? And as part of the answer, will you explain your view of the Washington Post?
Sure. Let me deal with what the differences are first. The big difference between a civilian proceeding and a military proceeding is the amount of information that has to be turned over to the defense. When they wrote the procedures for military commissions, there's a presumption in the military commission law that if something is classified, the defense doesn't get it. The presumption in the civilian system is that if something is relevant, the defense does get it. So you're starting out from the beginning with a situation where the prejudice on the civilian side is going to be toward disclosure. And I think we want it that way for cases that are supposed to be in the criminal justice system. I mean, the criminal justice system is designed for American citizens who are presumed innocent, and we want to have those protections for people who properly belong in it. The military justice system, on the other hand, is for disciplining, managing, and where appropriate, punishing enemies during wartime, which is a much different purpose. Think about the basic assumptions of our system, right? We often say about the civilian criminal justice system that we would rather see 10 guilty men go free than a single person be wrongly convicted. That's the basic conceit of our criminal justice system. We would actually rather see the government lose, in a sense. That is fine for people who belong in the criminal justice system. I don't think we would want to change it a whit. But when we're having a national security issue, when we're at war and we have to, and the national imperative is to defeat the enemy, we can't take the position that we'd rather see 10 guilty terrorists go free than one have his rights trammeled. The fact of life is you have to decide whether you're in a national security wartime mode or a peacetime mode, because the one thing that you cannot repeal is human error. There's going to be injustice no matter what system you're in. And what we're talking about basically is who bears the risk of error. In peacetime, when the civilian justice system is the set of procedures that we use, the government bears the risk of every error. The defendant gets the bounce of every ball, and that's absolutely the way that we should want it. On the other hand, if you're in a wartime scenario, you can't be giving the enemy every bounce of the ball. In fact, it's been the law of the United States since, I think, 1798. The Alien and Sedition Acts. The Sedition Acts were ultimately repealed. The alien part of it, or at least what I'm about to say, was not. But in a declared war, we are permitted actually to arrest and detain anybody who's in our country who is a national of the enemy. Not an operative, not a soldier, not somebody who's doing anything, just because the concept of citizenship meant that you had fealty to the enemy. That was enough, and has been enough for over 200 years, to be a rationale in a declared war for detaining people, just because they were citizens of the other side. The other thing about civilian versus military trials is, and this was the point that was really hammered home to me day after day trying to do these cases. Your incentive as a prosecutor, your duty as a prosecutor in one of these cases, is every day and almost every minute in collision with your duty as an official of the executive branch who has responsibility for the national security of the United States. Here's why. Once you decide to prosecute a terrorist, if you made the decision that you, in good faith, should bring the charges, that this person needs to be convicted, these are the worst of the worst in terms of offenders. Whether you decide they're criminals or warriors, they have to be neutralized. And we don't have debating society in the Justice Department. It didn't matter in 1993 or 1998 or whenever, or 2001, that I may have had qualms about the way our country was approaching this problem. I was a prosecutor in the Justice Department. If I got told, go prosecute that guy, the answer to that question was, well, do you really think we ought to be doing this? That's not our job there. Once you make the decision that somebody should be prosecuted, your obligation is to do everything within the law to make sure that you convict him and that he gets as much of a sentence as you can get, because these are the offenders who, if they get released, will turn back to mass murdering Americans. I mean, there's not rocket science about that. But what does that mean as a practical matter? What it means is when we draft indictments in terrorism cases, I don't know if you've ever seen any of these creatures, but I think that the indictment in our case was about 100 pages long. The indictment in the embassy bombing case, I think, was over 200 pages long. The reason that these indictments are so big and sweeping and narrative and descriptive is because conspiracy law is very forgiving to prosecutors in the federal system. We get all kinds of advantages that they don't have in many of the state systems. So we can get all kinds of hearsay into the case and background of the conspiracy and explanation of who is who in the conspiracy and how they interrelate. So what you do in order to exploit that as a prosecutor is you throw everything, including the kitchen sink, into the indictment in the hope that you will be able to get every piece of prejudicial evidence that the government has and make sure these guys get convicted. And when I say prejudicial in this sense, I'm talking about properly prejudicial. All evidence that properly comes into a trial prejudices the defendant. That's what it's designed to do. That's the point of it. Well, here's the problem with that. The broader you charge a case, the more things you put in the indictment, the more discovery obligations attach. For everything that you plead in a case, you turn that into a relevant issue in the case. Everything that's a relevant issue in a case allows a defense lawyer to come in and say, I want to see all the government's files about this, 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 and this. And it becomes very difficult for the government to go into court and say, we don't want to give you that. That's national defense information. The rules of civilian trials do not give the government any advantage in terms of the admissibility of evidence just because something is a national defense matter. What the courts would say, and I think actually this is quite a reasonable position, is if you, government, decide to bring somebody into the civilian justice system, then you have to play by the rules. And it's the rules that apply in the civilian justice system to every single case. With the exception of classified information in the civilian system is that you get to litigate before trial, whether it is admissible or not. But you don't get any advantage in the rules of evidence. If it's relevant and probative, it's admissible. If it's relevant and it passes the tests of discovery, they get disclosure of it, the defense does. If the court orders that they get disclosure and the government doesn't give disclosure, the court can start dismissing counts or even dismiss the case. You may recall in the Moussaoui case, the court, at least for a time, struck the death penalty notice because the government refused to make certain evidence and access to witnesses available to Moussaoui's defense. The Court of Appeals reinstated the death penalty when the government appealed that, but they also said, hey, look, government, we're going to watch very carefully how you proceed from here on in. And if Mr. Moussaoui doesn't get the evidence that he needs to make his defense, we keep the door open to striking counts, striking the death penalty, and striking whatever else he can't defend himself on because you won't give him discovery. What ended up happening? Moussaoui, against the advice of all the people who were advising him, all his lawyers, and much to the surprise of many people, pled guilty. And as a result, we don't know what would have happened if he had actually thrown down the gauntlet and we had to have a trial. The trial we had of Moussaoui was just the death penalty phase. It wasn't the liability phase of the trial where you find somebody guilty or not. The point is, your obligation as a prosecutor is to get everything into the case that you can get to assure, as best you can, the outcome that the person gets convicted and gets as much time as you can get for him. Your obligation as an executive branch official who's got some responsibility for the national security of the country, that's not prosecutors' main jobs, but we are, I still think of myself as a we, but prosecutors are officers of the executive branch. It's an executive branch responsibility to protect the American people and to prosecute war successfully. Your obligation on that score is to give the enemy as little information as possible, because you don't want to make them a more efficient killing machine, frankly, which is what you do when you turn over information. I mean, we tell them what we know, and by virtue of telling them what we know, that almost necessarily tells them how we know it, our methods and sources of information. Again, I think that's something we would never want to change in the criminal justice system for people who belong in it. They are presumed innocent and they're entitled to that information. But when we're at war, you can't be giving the enemy your most sensitive intelligence and telling them what you know about them and how you know it. And what I learned the hard way over the years, and this is not an easy lesson for a 30-something-year-old prosecutor who thinks, I got the biggest case in America. I'm the lead prosecutor. You haven't heard about me? Guess what you find out when you go down to the CIA? They actually think there's something that's more important than your little trial, whether we can keep people alive or not. And what they say to you is, we don't want to tell you this. We don't want to identify this witness, because if we tell you, you have to tell the defense. If you tell the defense, that source is blown. And you may be able to now win your trial, but we lose this person who's been giving us vital intelligence about Al-Qaeda. We lose this wiretap that's been very fruitful in terms of giving us all kinds of information. We lose this trail of terrorism financing that you're going to disclose and tell the bad guys that we know about it. We're using that information to try to track and map the terrorist organization. You find out pretty quickly that there are a lot of things that are more important to keeping Americans alive and to successfully prosecuting a war than success or failure in a trial. Yes, sir. I think they want you to have the microphone.
What is your prediction on the president and with the dilemma he's facing with his statement on the bomber, the Christmas government bomber?
Let me say two things. I get to that, and I want to get back to your question about the Washington Post, which I slipped my mind for a second. I don't agree with President Obama, obviously, on whether we ought to be bringing these people into the civilian justice system. But he's the president, and I respect, he won the election. This is not a shock. I mean, he campaigned on this. He thought that the pre-9/11 way of doing things was the better way to go. I thought that was an important election issue. And, it's tried to say, but elections have consequences. This is the policy he wants to install. There are two things I don't understand about his implementation of it, however. One is, again, there's no reason that you have to try these people now. Jose Padilla, the so-called dirty bomber, was held for about 4 years as an enemy combatant before he was prosecuted in the civilian justice system. He tried, when he was finally prosecuted in the civilian justice system, to argue to the court that the case should be thrown out because the government prejudiced his defense by holding him all those years as an enemy combatant. He lost. Another guy, Ali Al-Mari, who recently pled guilty, I think in the last several months, was actually held as an enemy combatant for about 7 years, I think, before we finally submitted him to the criminal justice system. So the point is that it's not like you have to have an either-or moment right when you bring somebody into custody. We can do it the way, I don't think it's the best way to do it, but you can do it the way President Obama wants to do it and Attorney General Holder want to do it, and still exploit the opportunity to get intelligence. And again, the only thing you lose are the statements, and particularly in the Abdul Muttalib case, you don't need the statements. He did what he did. In fact, I think it's so clear that you don't need the statements, that's probably why he's now cooperating with the government. He doesn't really have much of a defense to the case. So I don't understand the timing part of the implementation. But here's the other thing I don't get. if you say that we have to play by the rules and we have to bring somebody into the civilian system and we have to follow all of the rules and protocols of that system so that we can send a signal to the world about who we are as a people, why would you bring them into the system, or say you're going to bring them into the system, and then start undermining the system? When the President of the United States or a spokesman for the President or the Attorney General get up and say that this guy's going to be convicted and executed, you are undermining the system. Now, as it happens, I think this is utterly unnecessary. I don't want the President's hands being tied by a criminal proceeding. But this is his idea, not mine. And if you're going to play the game that way, you have to play by the rules. And the rules say that the government is not supposed to be making statements that prejudice the potential jury pool. And all you're doing when you do that, and they keep doing it, I don't understand why they keep doing it, but all you're doing is giving the defense the ability to come in and either seek a dismissal of the indictment or a lengthy postponement until such time, if ever, that they can get a fair trial. Now, do I think that motion will succeed? No. But why would we want to litigate it? You know, there's a lot of things that the government does that won't be fatal in terms of the outcome of the case. But at the same time, there's no reason to, believe me, these cases are high stakes, high pressure affairs. Everybody makes mistakes in them. If I know anything, it's because I've made every mistake you could make twice. Okay, I mean, that's just the way it is. And anyone who tells you that's not true has never been trusted with anything important to try. That's just a fact of life. You're going to have mistakes. So why give them a freebie? And this is really a freebie, and it's not a good thing to undermine. To get back to the Washington Post article. My sense from the Washington Post article is that I think it's a head fake for the following reason. What it says is that Obama is potentially standing down on the objection to military commissions. That's plainly not true. He's already done that. On the same day, people don't realize this, but on the same day that Attorney General Holder announced that the 9/11 plotters would be getting a civilian trial, they also announced that the Cole bombers, the bombers of the USS Cole in October of 2000, who killed 17 members of the US Navy, would be going to a military commission. So the Obama administration has already preserved the military commissions. They've already submitted a case to the military commission, and in 2009, Congress, for the third time, endorsed the military commissions. So we already have military commissions. And the trajectory of what's going on here is trending, I think, toward a military commission, certainly for the 9/11 plotters, and probably for most of the other enemy combatants who will be tried. I don't think all of them will be tried. There'll probably be a good number of them who can't be tried. So why the big announcement today? I think the reason for the big announcement is to suggest that Obama, the president, is being reasonable and magnanimous and staring down his base, which is going to be very upset about this. So isn't it time for the rest of us to be reasonable and close Gitmo? And I think the game here, the ball that you ought to keep your eye on is, this is an initiative, the end game of which is to close Guantanamo Bay. The idea is they compromise on military commissions, so why can't the rest of us be big guys and compromise about Gitmo and close that place down? Here's why. This is not horse trading on, a farm bill. This is the national security of the United States. It may be one thing in ordinary legislation to say, all right, you do this and I'll do that, and you give me this and I'll give you that. But in national security, you don't do a stupid thing that will endanger the country because your opposition has magnanimously agreed not to insist that you do two stupid things to endanger the country. That doesn't make any sense. Bringing these people into this country is going to be bad on a number of levels. Number one, once they are physically here, there is no argument anymore that the courts don't have complete jurisdiction over them. What I think has stopped judges from trying to release, and some judges have tried to release some of these guys and actually even insist that they be brought in the United States. But what has stopped that up until now is they are physically outside the United States. They're aliens who don't have any right to be in the United States, and we have a statute that says that they're excludable from the United States if they're trained terrorists. Once they're physically here, all bets are off, and you'll see courts vesting them with all, not just habeas corpus rights, but I think all the rights of the Constitution. And let's not fool ourselves about what we're talking about here. The combatants who will be brought into this country, if they're brought in, will be not only war criminals, but people who we can't try because we know they're dangerous, because we've got all kinds of intelligence about that, or there's interrogation information that can't be used. We're confident that information is correct, but it's inadmissible in court, not just in civilian court, in military court as well. These are going to be people who will be therefore detained indefinitely without being tried. Nothing offends the legal profession, the legal culture, and the federal bench more than the idea that people are in custody for however long, for who knows how long they'll be in custody, without having a trial. And that, after a time, I don't know if it'll be weeks or months or years, but I'm telling you, bank on it. If they're here, judges are going to start releasing them. And once they're physically present in the United States, there's no argument anymore that they have to be released someplace else.
This will be our final question.
Okay. Well, let me ask Hans then.
Andy, I got a question that I agree 100% with you about military tribunals, but I worry because of this. I have a former colleague at the Department of Justice who for a while was going out in Guantanamo, and he said to me he questioned the quality of judges of the military tribunal and the quality of the prosecutors. He told me that he didn't think the military had done a very good job in getting high-quality judges. He also said the prosecutors were not very good, and he said because of the off-again, on-again matter of military tribunals, that there were none of the really good prosecutors at justice, and there still are very good prosecutors there despite the leadership for the past year, have been attracted to going down there on details to doing that. So he's really worried about the quality of the lawyers involved in the military tribunals.
Well, let me say a couple of things about that, Hans. Number one, I think that, the team that had the KSM case was made up of both Defense Department lawyers and Justice Department lawyers. There were either 2 or 3 DOJ lawyers on that team. We've had, I don't think the military commission system performed well. I mean, certainly in the first case, it was deplorable. The Hamdan, who was bin Laden's driver and bodyguard, got what effectively was time served. I mean, he got about a 5-month sentence, and then he was released. He's no longer even in custody. In the civilian system, in front of the judges I prosecuted in front of, and my office prosecuted in front of in the 90s, look, it's not easy to convict people, but once you convict them, they get slammed. I had a guy in my case his meter was ticking for about 40 minutes in the whole conspiracy. He got 25 years because the FBI came in and there he was mixing explosives. So yes, it's performed badly. I think there's been a couple of times, frankly, that the civilian system has performed not particularly well either. But by and large, the civilian system has done a good job. Number one, I don't think it has to be the case that it's just Defense Department lawyers in these cases. There are good military judges and there are bad military judges, just like there are good and bad civilian judges. But what I would like to take a short opportunity to say is, look, having looked at this both ways and having lived it, gun to my head, if I have to make a call between civilian system and military system, I choose the military system because of the intelligence ramifications. But I started proposing in 2004 that we stop having this fight about should it be military or should it be civilian, and put our heads together to design a system that actually is tailored to this challenge. I think what you could do, I called it a national security court. Other people have other names for it. But I think what you could do is you could largely adopt the military procedures, but bring in regular federal judges to try the cases. This would have a couple of consequences. One of them is, I think, with due respect to the military system, you would get an increase in the competence of the way these cases were handled. Not because the military judges are incompetent, but because the federal judges have actually been through this going back now to 1993. And we ought to be exploiting that competence. The second thing it would do is it would foster some cooperation between the United States and our allies. Now, ordinarily, my knuckle-dragging Neanderthal position is, who cares what the French think? And I don't like having to care what the Europeans think. But we do have to care. Because if we don't have a system that they will cooperate with, then they won't extradite people who are dangerous to the United States to that system so that we can deal with them. And if they won't, what that ends up meaning is that you're outsourcing your national security to countries that have a lot less interest in it than you do. It doesn't really matter that I think military tribunals are peachy and that I think they're perfectly fine under the Constitution and they've been used since George Washington. You know, we could talk all day long about why they're fine and why it's a system with integrity and a good system. The fact is, the Europeans and the international community, whatever that means, will not cooperate with a system that they regard as a unilateral executive branch show, where the executive branch is the prosecutor, the judge, and the jury. They think that is not a system that has integrity. I think they're wrong, but who cares what I think? It's their right to make that conclusion, and they have made it. I think if we put federal judges, regular federal judges, Article 3 of the Constitution judges, presiding over these proceedings, that answers that criticism, because now you have an independent branch of government which is overseeing these proceedings. I'm more sensitive than anyone, I think, to the idea that we don't want judges freelancing in national security. So I think what this would require, if we were going to implement it, what would be Congress would have to write a very exacting national security court law with very detailed procedures, and it would have to write in a provision that said, unless we've spelled out a right here, the right doesn't exist, and courts are not at liberty to use the interstices between the provisions in order to inflate the due process rights. That if that's going to happen, that Congress has to do it. But I think if you got that measure of protection against judicial freelancing, there'd be a lot to be said for a system where you had regular federal judges. No reason the Justice Department shouldn't be a major player in this. In cooperation with the Defense Department, use the military procedures and the presumptions Congress has given us to protect national security information, but have Article 3 judges preside. Take that to the international community and say, see, we're giving you an olive branch that we can deal with. Please cooperate with our system and let us deal with the people who are a threat to us. I think there's the makings of that deal. And there are even people in the Obama administration, I think, who are very thoughtful people who think it's a good idea. Don't tell them I thought it's a good idea, because it may change their minds. But I think it's the right thing to do, and it would be a lot better for the country than continuing this argument about civilian versus military. And unlike President Bush, Obama has the political moment to get it done. I mean, if he wanted to do it, he's got people in the Justice Department who would be superb at designing it. He's got a Congress in his own control. And he now, after I think what's been a very hard year plus for him, sees maybe in a way that he didn't before he was in power how difficult and complicated this is. It's something we should do. I don't know why we don't. Thank you.
Thank you.
Thank you.